back to our MD's I Law channel where every case is clear. If you are new here, I am Kritik and this is part 9 of our AIBE 17 previous paper analysis series. Today, we are diving deep into some of the most important questions from the AIBE 17 exam, breaking them down to help you prepare effectively. Whether you are gearing up for your exam or just looking to understand the legal landscape better, you are in the right place. Let's get started. 81st question is: which of the following order deals with death, marriage and insolvency of parties? The correct option is C, Order 22. This order deals with the death, marriage and insolvency of parties in a civil suit. It specifies the procedure to be followed when a party dies, marries or becomes insolvent during the pendency of the suit. It also provides for the substitution of the legal representatives of the deceased party, the effect of abatement and revival of the suit, and the determination of the question as to the legal representative of the deceased party. 82nd question is a repetitive question, so please concentrate. The doctrine of res gestae has been discussed in which section of the Evidence Act? The correct option is B, Section 6. Section 6 of the Indian Evidence Act deals with the concept of res gestae, which means things done in Latin. It allows for the admission of facts that are so connected with the fact in issue that they form part of the same transaction. These facts are considered relevant even though they may not be directly in issue or in dispute. For example, suppose a crime takes place, such as a murder, and a witness hears a loud argument followed by a gunshot. The argument and the gunshot are events connected with the murder, and thus, statements made during the argument and immediately before or after the gunshot can be considered part of the same transaction and are admissible as evidence. 83rd question is: when the liability of a person who is one of the parties to the suit depends upon the liability of a stranger to the suit, then an admission by the stranger in respect of his liability shall be an admission on the part of that person who is a party to the suit. It has been so provided under which section of the Indian Evidence Act, 1872? The correct option is C, Section 19. This section states that admissions by persons whose position must be proved as against party to suit are relevant. This means that when the liability of a person who is one of the parties to the suit depends upon the liability of a stranger to the suit, then an admission by the stranger in respect of his liability shall be an admission on the part of that person who is a party to the suit. Section 19 is based on the principle of estoppel, which prevents a person from denying or contradicting a fact that he has previously admitted or asserted. Section 19 is also an exception to the rule that hearsay evidence is not admissible, as it allows the admission of a third party to affect the rights and liabilities of the parties to the suit. For example, in a case, fact in issue is dispute over the ownership of a piece of land. Parties involved are person A claims ownership of the land against person B. Relevant admission is person C, who is the tenant on the disputed land, states that he has been paying rent to person A and recognizes person A as the landlord. Here, person C's statement is relevant because person C's position as a tenant, whose liability to pay rent needs to be proved against person B, makes his admission relevant. 84th question is very easy one. Judicial evidence means. The correct option is A, evidence received by courts in proof or disproof of facts. Judicial evidence refers to evidence that the court accepts to establish or reject the facts in question. Such evidence includes confessions of the accused, statements of witnesses, documentary evidence, and facts presented for examination by the court. Evidence received by police officers is typically referred to as investigatory evidence. The Home Department is a governmental body, and evidence received by this department would be considered administrative or investigatory evidence. 85th question is: which of the following is not a document, according to the Indian Evidence Act, 1872? The correct option is D, none of these. According to the Indian Evidence Act, 1872, Section 3 defines document as including any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means, intended to be used, or which may be used, for the purpose of recording that matter. For example, written letters, printed material, electronic records, photographs, maps and plans, engravings and inscriptions, audio and video recordings and more. 86th question is on presumptions, and make sure to revise these types of presumption questions at least once before going to the exam. And the question is, presumptions as to dowry debts is given under which section? The correct option is B, 113B. According to this section, when the question is whether a person has committed the dowry debt of a woman and it is shown that soon before her death such woman has been subjected by such person to cruelty or harassment for, or in connection with, any demand for dowry, the court shall presume that such person had caused the dowry debt. This section was added by the Dowry Prohibition Amendment Act 1986 to provide speedy justice in cases of dowry debts and protect women from such torture. This section also defines dowry debt as having the same meaning as in Section 304B of the Indian Penal Code, which is the death of a woman within 7 years of her marriage due to burn or any other bodily injury and had occurred under abnormal conditions. 87th question is, which of the following is not secondary evidence as per Section 63 of Indian Evidence Act, 1872? The correct option is D, copies not certified under Section 63. According to Section 63 of the Indian Evidence Act, 1872, secondary evidence includes certified copies, copies made by mechanical processes ensuring accuracy, copies made from or compared with the original, counterparts of documents against non-executing parties, and oral accounts by someone who has seen the document. Thus, uncertified copies do not qualify as secondary evidence and are inadmissible. 88th question is, which of the following provision of Civil Procedure Code, 1908 deals with the institution of suits? The correct option is C, Section 26. This section deals with the institution of suits, which means the initiation or commencement of a civil suit by the presentation of a plaint or in such other manner as may be prescribed. A plaint is a written statement of the claim or grievance of the plaintiff against the defendant. Section 26(2) provides that in every plaint, facts shall be proved by affidavit. An affidavit is a sworn statement of facts made before a person who has authority to administer an oath. 89th question is, defendant shall, within days from the date of service of summons on him, present a written statement of his defense, Order 8. The correct option is B, 30. According to Rule 1 of Order 8 of the Code of Civil Procedure, the defendant shall, within 30 days from the date of service of summons on him, present a written statement of his defense. However, if the defendant fails to file the written statement within 30 days, the court may, in exceptional circumstances and for reasons to be recorded in writing, extend the period by a further 60 days, but not beyond a total period of 90 days from the date of service of summons. 90th question is, the arbitral tribunal shall not be bound by dash in the determination of rules of procedure. The correct answer is D, both the Code of Civil Procedure, 1908, and the Indian Evidence Act, 1872. Section 19 of the Arbitration and Conciliation Act, 1996, specifies that the arbitral tribunal is not bound by the Code of Civil Procedure, 1908, or the Indian Evidence Act, 1872. This flexibility allows the tribunal to adopt procedures that are more efficient and tailored to the specific needs of the arbitration. This provision ensures that arbitration proceedings are conducted fairly and impartially, without the constraints of traditional court formalities, promoting an effective resolution of disputes. Thanks for tuning into this part of our AIBE 17 analysis series. We hope you found the insights helpful for your exam preparation. If enjoyed the video, please give it a thumbs up, subscribe and hit that notification bell so you don't miss the next part in the series. Share your thoughts or questions in the comments below. We love hearing from you. Until next time, keep studying, stay focused and good luck on your journey. See